My dear friends, my colleagues in legal profession, and my fellow citizens and defenders of democracy and secularism, today I would like to share my views on judicial office, constitutional morality and the limits of personal opinion. In the wake of recent remarks of a judge of Madras High Court, my friends, recently Justice J.R. Swaminathan of the Madras High Court, while speaking at Guru Vandana Utsava organized by Hosur Satsang at private school in Hosur, Tamil Nadu, reportedly remarked that the rationalists who describe those treating a guru as equal to God as fools, incompetent, and barbarians are themselves fools, rascals, and barbarians. The judge had recently made headlines for another remark that he would carry Sanatana Dharma close to his heart for the rest of his tenure as a judge. The judge is already encountered similar situation in the aftermath of his order permitting temple devotees to light a lamp at a stone pillar atop Tirupparanathandram hill near a dargah, for which an impeachment motion was initiated in the parliament against him. The remarks by Justice J.R. Swaminathan cannot be dismissed as stray observations. They must be examined in the larger context of repeated judicial pronouncements and public conduct that raise serious constitutional concerns. The statement has triggered serious concern within the section of legal fraternity, civil society, and among constitutional scholars. The issue is not about the belief versus non-belief, nor is it about defending rationalists or condemning the communalists. The question is not whether a judge has personal beliefs. Every judge does. The question is whether those beliefs visibly inform judicial reasoning or public conduct. The issue is about the constitutional role of a High Court judge and the limits imposed by judicial office. My friends, what is the constitutional position? Under Article 214 of the Constitution, High Court judges will be appointed, and judges take an oath under Article 219 to bear the true faith and allegiance to the Constitution of India and to perform the duties of the office without fear or favor, affection or ill will. The oath is not ceremonial, my friends. It is a constitutional discipline. The judiciary in India derives its legitimacy not from popularity, ideology, religion, or majoritarian sentiment, but from the Constitution. The oath does not permit ideological preference. It does not permit cultural majoritarian signaling. It demands neutrality. The Supreme Court in S.P. Gupta versus Union of India emphasized judicial independence as a basic structure of the Constitution. Later, in the Supreme Court Advocates on Record Association versus Union of India, the court reiterated that judicial independence is essential to preserve constitutional governance. Independence, however, is not ideological freedom. It is institutional restraint. My friends, freedom of expression versus judicial restraint. My friends, every citizen enjoys freedom of speech under Article 19(1) subclause A of Constitution of India. But judges, by virtue of their office, accept self-imposed constitutional limitations. In K. Veeraswamy versus Union of India, the Supreme Court underscored that judges are held to higher standards of conduct because public confidence in the judiciary is foundational to democracy. When a sitting constitutional judge uses language such as fools, rascals, incompetent, and barbarians, even in rhetorical counter commentary, it raises legitimate concerns. Does such language reflect constitutional detachment? Does it align with the oath to act without affection or ill will? Does it maintain the dignity expected of a constitutional court? The question is institutional and not personal, my friends. Then, India's secularism declared as a part of the basic structure in S.R. Bommai versus Union of India, which requires the state, including the judiciary, to maintain principled neutrality among beliefs. A judge may personally hold spiritual or philosophical convictions, but when such convictions appear in judicial reasoning or public remarks in a manner that could be perceived as endorsing one world view over the another, constitutional concerns arise. Rationalism is not anti-constitutional. Faith is not anti-constitutional. The religion is not anti-constitutional. The Constitution protects both. Article 25 guarantees freedom of conscience, which includes the right to believe, not to believe, and to question the belief. When a constitutional judge publicly defends Hindutva ideology, either directly or by rhetorical framing, it creates a perception that the court is not equally distant from all belief systems. Perception matters. When judicial language appears to delegitimize one segment of citizens for exercising their freedom of conscience, it risks undermining the constitutional balance. My friends, judicial temperament and public confidence is most important. The legitimacy of the courts depends on public confidence. As observed in R.C. Chandel versus High Court of MP, judges must exhibit restraint, sobriety, and balance because their words carry institutional authority. The issue is not whether a judge can disagree with a rationalist criticism. The issue is whether such disagreement should be expressed in language unbecoming of a constitutional office. Courts are not platforms for philosophical counterattacks. They are forums for reasoned adjudication. My friends, when a judge appears to be ideologically aligned, the difficulty is not merely doctrinal, it is structural. If litigants belong to a minority community or the community of different faith and rationalist movements or dissenting voices, ideological groups approach a court presided over by a judge who has publicly defended majoritarian ideology, will they feel assured of equal treatment? No. Constitutional courts must be safe spaces for religious minorities, atheists and rationalists, political dissenters, and marginalized communities. Any erosion of this confidence is institutional damage. My friends, what is the procedure? Removal and constitutional mechanism under Article 124, subclass 4 and 217, read with Judges Enquiries Act, a High Court judge can be removed only through impeachment for proved misbehavior or incapacity. Removal is an extreme constitutional remedy. It cannot be invoked for a mere disagreement with the judge's views. However, repeated conduct that raises questions about adherence to the constitutional principles invites scrutiny from the in-house judicial mechanism, the collegium system, and parliament, in rare cases through impeachment proceeding. Institutional accountability is a part of judicial independence. My friends, in C. Ravichandran Iyer versus Justice M. Bhattacharjee, 1995, reported in 1995 SCC Volume 5, page 457, the Supreme Court candidly acknowledged this institutional dilemma. The court noted the yawning gap between conduct that may undermine public confidence in the judiciary and the stringent constitutional threshold required for impeachment. It made three crucial clarifications. Concerns about judicial conduct cannot be addressed through public campaigns or coercive pressure. Not every allegation can or should be escalated to impeachment. An intermediate institutional mechanism is necessary to preserve both judicial independence and public confidence. This was a remarkable moment of judicial introspection. The court recognized that the impeachment is too blunt and too political a tool to address non-answered concerns of the judicial propriety. In the wake of Ravichandran Iyer judgment, the Supreme Court formulated the in-house procedure to address complaints against judges. In 1997, it adopted the restatement of values of judicial life, later reaffirmed at the 1999 Conference of Chief Justices of all High Courts. Though non-statutory, the restatement articulated principles of impartiality, institutional aloofness, avoidance of conflicts of interest, dignity in public expression, and ethical and restraint in extrajudicial conduct. It represented the judiciary's own articulation of ethical standards, a form of self-discipline essential to constitutional legitimacy. The underlying philosophy was simple. Judicial independence cannot survive without judicial accountability. So what is the need for legislative reform? Parliament attempted to reform through the Judicial Standards and Accountability Bill passed in Lok Sabha in 2012, but it was lapsed and never enacted. A modern judicial accountability framework must codify standards of conduct, create an independent oversight body, provide graded sanctions, distinguish judicial error from misconduct, and protect judges from political retaliation. Without such reform, impeachment becomes the only visible remedy, even where it may be disproportionate. So, my friends, then the silence of the apex court. The more troubling dimension is institutional silence. The Supreme Court of India, as the guardian of constitutional values, exercises administrative and moral authority over the higher judiciary through collegium system. When repeated public controversies arise and no visible corrective response follows, it risks sending a signal that such conduct is tolerable. Silence in such circumstances may unintentionally embolden further rhetorical departures from the constitutional neutrality. Judicial discipline is not interference, it is preservation of institutional credibility. My friends, the present controversy is not about punishing dissenting philosophy. It is about ensuring that judges refrain from rhetorical denunciation of identifiable ideological groups. Ethical concerns are addressed institutionally and public confidence is preserved. The framers designed impeachment to be rare. They did not design silence to be permanent. And an institution cannot indefinitely postpone reforms it knows it requires. The Constitution envisaged an independent judiciary sustained by credible, depoliticized accountability. What is the way forward? This movement calls for not for outrage, my friends, but for introspection within the judiciary. Judges are guardians of constitutional morality, a concept emphasized by Father of Indian Constitution, Dr. B.R. Ambedkar, and affirmed in Navatej Singh Johar versus Union of India. Constitutional morality demands restraint, neutrality, and dignity. The judiciary must rise above rhetoric. The Constitution must remain above all belief systems. The present controversy is not simply about one incident. It is a reminder that an institution cannot indefinitely postpone the reforms it knows it requires. A modern judicial accountability law must be revived. Such legislation should codify judicial standards consistent with the restatement of values of judicial life, establish an independent oversight body composed of senior judges, juries, and non-political constitutional members, then create graded sanctions, advisory, cautionary, or recommendatory, short impeachment, and protect judges from politically motivated complaints, clear distinguish between judicial error and ethical misconduct. Such reforms would give genuine grievances a credible forum, provide judges with protection from political retaliation, and remove the temptation to use impeachment as a tool of pressure. Thank you, my friends.